had an opportunity to review the arrest report in this case, and the court does find that there is probable cause in this case. Mr. Whitaker, are you here?
I am. Mr. Cole.
Mr. Cole,
Yes, ma'am.
is it your understanding that Mr. Whitaker is representing you?
Yes, Your Honor.
Okay, thank you so much. Give me one moment. All right, the court did review the arrest report. I'll hear from court services, and then I'll hear from Mr. Wood.
Thank you.
Your Honor, this defendant did report 14 years tied to Rockland County, 54 years tied to the state of Florida, where he's currently a business owner for the past 10 years. He is showing no other criminal history, and he has no failure to appear. We would recommend he have no contact with the listed victim in the case, and he have no unsupervised contact with minors.
Okay, Mr. Whitaker.
Morning, Your Honor. For the record, John Whitaker on his behalf. I want to note a couple of things. Obviously, you've already been told that he doesn't have any criminal history. His wife and family, including the alleged victim and his brother, are here in support if the court needed to hear or confirm any of that information. I would note the report does indicate that he was fully cooperative with the investigation. In addition, Your Honor, I am aware that DCF is involved and the family is cooperating, and the interviews have occurred in regards to the collateral investigation. I do believe that, given the fact that the alleged victim lives in the home, that I advise the family that I believe the court would require or maintain an alternate residence. We would have any objection to doing that. Given the fact that he has no criminal history, has long ties to the community as a business owner, he's not a flight risk. I'd also note to the court that I don't believe he's a risk to the community given the nature of the allegations and the opportunity as have the allegations occurred. That's not something that would be out there. It's not a crime of violence. It's an allegation. It's a crime of opportunity. Obviously, maintaining no contact with that individual and no unsupervised contact with minors. We'd be asking for a reasonable bond given all of those ties, the lack of criminal history, and the nature of how the allegation alleged to occur.
and the concerning facts and circumstances surrounding these particular charges, as well as the weight of the evidence against the defendant, particularly as it relates to count 2, which he admits that he suspected and subsequently came to find out from admissions that this was situation was ongoing between the juveniles. The state would be asking for a monetary and substantial bond as to these charges. In addition, the state would like the court to be aware that there was a search warrant executed on the defendant's property late last night, and there may be additional charges as well.
You're gonna already briefly heard in that regard. Obviously, we can address that if that becomes necessary, but in terms of the purpose and of bail, the court's well aware, is one, to ensure his return to court, which I don't believe there's any indication that he's not going to return to court given his ties to the community and the lack of criminal history and support that he has, including his family, in terms of substantial monetary bond. Unfortunately, these types of situations are things that do occur, and sometimes families, if the allegations are true, don't respond appropriately in terms of self-reporting to PCF, but that's not, unfortunately, uncommon because of trying to resolve the situation rather than taking it to the court system, not to excuse the behavior, but a substantial monetary bond, I don't believe serves any purpose other than punitive to him, which we're not at that point. We're here only to determine whether or not he's going to return to court and whether or not he poses any continued danger to the community.
Your Honor, the state would only add that if the defendant knew to which he admitted he did for 2 years that this was ongoing, that is a danger to the community. And the state would ask for a monetary bond in this case.
Based on the allegations in this report, the court does believe it's appropriate to set a bond in this case. The nature of these particular cases also relates to the court's factors as well as all the other factors that were indicated as it relates to the ties to the community as well as the age of the victims that are alleged in this case. The court is going to set special conditions. The special conditions are going to be that the school have no direct or indirect contact with the victim in this case. That means no contact whatsoever, no phone calls, no text messages, no contact from third parties. And the court is going to order that the jail give a standing no contact order, and that you abide by each and every condition of that order, that you have no unsupervised contact with minors under the age of 18 years of age, that you maintain an alternate residence, and the court will authorize a one-time visit of law enforcement officers to pick up any personal belongings that you may have. As it relates to count 1, the court is going to set the bond at an amount of $50,000. And as it relates to count 2, the court is going to set that bond also at an amount of $50,000. That's the order of the court. Take care.
Take care. So no matter how the court may be excused.
The next case is Jalen Kitnam.
Good morning, Your Honor.
Good morning. Good morning, Mr. Kitnam. Okay, let me set the record. We're here in case 2022 CF 3447A, and Mr. Kitnam, you're here. You're charged with 5 counts of possession of obscene material, That promotes, sexual performance by a child. Do you understand the charges, sir? Okay. And, give me one moment, I believe I have your attorney here. Okay, thank you. All right. Mr. Kitten, I believe, you have, an attorney appearing here on your behalf. I'm gonna hear from him and some other folks, and then I'll come back to you. Yes, sir.
Thank you, Your Honor. Good morning, Judge again. Ron Kozlowski, for the record, on behalf of Mr. Kidna. I'm here with my law partner, Caleb Kenyon. And also here this morning, Your Honor, are Jalen's parents, John and Jennifer, and his local pastor, Kevin Sides, and Pastor Sides' wife, just to identify the parties for the court. Also, Your Honor, co-counsel in the case will be Mr. Hank Cox and Brian Hoffman of the Bedell firm in Jacksonville. I understand that a Zoom link was requested so they could view the proceedings, and I don't think that's been accomplished, so I just want to mention that to the court again and ask if that is possible.
We don't typically have that set up for first appearances during the week, and I don't believe that there was an ability for them to be able to try to set that up, with the timing that we had to be able to prepare for that. It's only usually arranged for weekends, is my understanding.
Okay, Your Honor. Also, on the issue of the charges, the clerk's site right now is showing incorrect charges, as the court just announced them. The first two actually should be under 827.
Give me one moment, let me
Sure.
get the following.
Of course.
I am pulling up the case and, okay, I see, the charges, listed, you may proceed.
Okay, Your Honor, it's a distinction that I think the court might find important, but counts 1 and 2 in the report are listed under, and appropriately so, based on the probable cause affidavit, are listed as 827.071 sub 4 for counts 1 and 2, and for counts 3, 4, and 5, 827.071 sub 5. The counts 1 and 2 under sub 4 are the promotion charges that the court announced. Under sub 5 is simple possession, and that is a distinction with some importance, Your Honor.
Counts 3 through 4.
3, 4, and 5.
Okay, the court does note, in looking at the arrest report, counts 3, 4, and 5 are listed as possession of photograph of sexual performance by a child for counts 3 and 4. Do you believe that that is what it's supposed to be?
I believe all the 3, 4, and 5 should be under 827.071 subsection 5, which is simple possession.
Okay, that's what the court has here.
Okay.
And Madam Clerk, is that what you were correct? That's on it. Okay. So yes, they did provide correct or corrected information on the first appearance. And then count 2, 1 and 2 is listed as possession and promoting sexual performance by a child. And that is 827.071 sub 4. Okay.
Thank you, Your Honor.
The court, court will hear from court services, and I'll come back to you, Mr. Clark.
Thank you.
Your Honor, the defendant did report a 2-year time in Washington County, 2 years out in the state of Florida, and is currently a student at the University of Florida for 2 years. He has shown no other criminal history, he has no failure to appear. We would recommend he have no contact with minors in the case and have no internet or computer access.
Okay, Mr. Kozlowski.
Thank you, Your Honor. We're going to be asking that the court, as we believe is proper under the applicable law, that Mr. Kidna be released to the custody of his parents, where they would return home with him to Texas while on pretrial release. And if the court is not prepared to make that decision without further discussion and presentation of that case law, Mr. Kenyon will address the court at the appropriate time.
If you have any case law, or anything that you would like to add, Mr. Kenyon, for the,
Thank you, Your Honor. For the record, Caleb Kenyon on behalf of Mr. Kidna. Your Honor, as a preliminary note, I would like to first address that this is a case that involves an allegation of child pornography. And child pornography is one of those crimes that I think everyone in this courtroom would agree is pretty terrible. The fact that it even exists in the world is tragic. Child pornography cases tend to evoke a pretty strong emotional response. Most of us have kids or were kids or know kids, and so there's a very emotional response. However, as officers of the court here, it's our job, all the attorneys, Your Honor, the staff here, it's our job to move past the emotions and look at what the law says, particularly as it relates to child pornography. It was under the child pornography laws of the state of Florida that Mr. Kidna was arrested. And so, Your Honor, the laws of the state of Florida equally govern his pretrial release. And so we can't pick and choose. We have to equally follow the law. So as a preliminary piece of law, the Florida Constitution, Article 1, Section 14, it guarantees, it doesn't just presume, but it guarantees that Mr. Kidna is entitled to pretrial release. This is not a capital offense. It's not punishable by life. He is guaranteed the right to reasonable conditions of release. So as just the most fundamental and basic, the Constitution of our land says that he is entitled to pretrial release. But, Your Honor, the law goes further than just that constitutional guarantee. We have Florida Statute 907.041, which governs pretrial release. This statute governs pretrial detention. It enumerates when a monetary release, a monetary bond as a condition of release is appropriate. And if you'll look at this, Your Honor, subsection 3, it specifically says release on non-monetary conditions. Then if you look at subsection A under that, and I've highlighted it there on your copy for your benefit, under the law, Mr. Kidna is presumed entitled to a non-monetary bond. If you continue reading, and I've highlighted on the next page, where you have the term dangerous crime, which is enumerated by the statute. Essentially, there's some double negatives in there, but if you're charged with a dangerous crime, you are not presumed entitled to a non-monetary bond, so the court's free to impose a monetary bond. But if the crime that you're accused of is not a dangerous crime, you are presumed by law to be entitled to a non-monetary bond. And I will represent to the court and give you more than a chance to look through 4A, subsection 1 through 23 are the enumerated dangerous crimes, and child pornography, whether simple possession or promotion, is nowhere in that list. The reality is child pornography is an internet crime. It's not a hands-on offense. It's not a crime that has a physical danger component. This simple possession of it. And so, as such, Florida law says not only is Mr. Kitna entitled constitutionally to pretrial release on reasonable conditions, but he is presumed entitled to a non-monetary bond. The law actually is even more clear and more in favor of the request we're asking. I'm going to provide Your Honor with a copy of the Rule of Criminal Procedure, Florida Rule of Criminal Procedure. This is 3.131, which governs how Your Honor conducts first appearance and what Your Honor should and should not consider when deciding conditions of release. If you look, Your Honor, at subsection B, which is titled Hearing at First Appearance, Conditions of Release, I've highlighted some language there for Your Honor. The highlighted language reads, quote, "The judicial officer shall impose the first," and I'm going to emphasize that word first because it's important, "of the following conditions of release that will reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process." So we have three criteria that this court is looking to accomplish by setting pretrial release, and the court has to pick the first of this enumerated list, which is subsections A through F. But first I would like to address the three different criteria that the court is supposed to evaluate. The first one, reasonably protect the community from risk of physical harm. Now, it doesn't say any harm, it specifies physical harm. We're dealing with an internet crime. We're dealing with a crime, and I'm not trying to downplay the seriousness of possessing child pornography, but we're dealing with a crime that can be accomplished with 2 clicks of a mouse. This is not a crime that threatens physical harm. This is not a case where there's any indication whatsoever of hands-on offense, where there's any indication whatsoever of anything other than a couple of clicks on a computer mouse or on a phone. So there is no evidence whatsoever in the pretty lengthy arrest report that there's any indication of physical harm to the community. So that entire category is inapplicable to the case against and the allegations against Mr. Kitna. The second criteria, for Your Honor, is to assure the presence of the accused at trial. And I think this is going to be the crux of the analysis, for Your Honor. I'll address that in a second, but I want to go to number 3, or assure the integrity of the judicial process. Similarly to the first one, assuring the integrity of the judicial process is not something that we're dealing with in this case. This is not a case where Mr. Kitna is being accused of being a part of the mafia or organized crime, where there's a threat of bribing witnesses or harming witnesses to alter testimony and corrupt the judicial process. This is an internet